Hey, I'm Paul Rabelais, estate planning attorney, and in this video we're going to talk about whether your annuities are safe from the nursing home. Okay, so if you've been watching any of my videos, you see that certainly a lot more than a handful of my videos address people qualifying for Medicaid if they go into a nursing home, along with strategies on how to protect their savings, their home, from losing those things because the cost of long-term care, nursing home care is so high. So it's just the way it is these days in America. Kind of the biggest threat to people losing their estate is getting sick and needing that long-term care and having to pay for it and having that drain their estate. So I base these videos and base the content of the videos on the kinds of questions that are asked of me, the kinds of problems that are posed to me from out there, everyday ordinary people just trying to hold on to what they have and save a little bit for themselves and their spouse and potentially their children, heck, maybe even their grandchildren one day. And so this is another one of those questions that gets posed to me from time to time in the area of protecting the estate from nursing home expenses, Medicaid eligibility, elder law, whatever you want to call it. So this one addresses, though, whether annuities are protected. So let me give you some background from the Medicaid eligibility 101. So there's some different standards for how much you can own if you go into a nursing home to be eligible for Medicaid. If a single unmarried person goes into a nursing home, if they have more than $2,000 of countable resources, they're not going to be eligible until they spend down and have less than $2,000. If there's a married couple and both spouses go into the nursing home together, they have to spend all of their countable resources down to less than $3,000 before Medicaid will cover that nursing home expense. And then if you have a situation, which is common, where you have a married couple, but only one spouse goes into the nursing home, that spouse is called the institutionalized spouse. They're in an institution. And then one spouse still living at home, that spouse is called the community spouse because they're still living in the community. So that couple can have, at least in 2019, $126,420, really $2,000 more than that, $128,420. For 2020, that $126 will probably jump up to around $128,000 or so because it's adjusted for inflation. The idea is the one who is at home needs some resources to live off of while their spouse is in the nursing home. So all of those figures are relevant as we talk about annuities and we get through this video. So let's jump right in to are annuities protected? Annuities are a complicated subject. A lot of bad press about annuities, perhaps justifiably, lots of kinds of annuities. But for purposes of our discussion, we're going to say there's two kinds of annuities. There's the deferred annuity and there's the immediate annuity. First, let's talk about the deferred annuity. That's a countable resource. And oh, by the way, a countable resource is really anything other than your home and your car. There's a few other exceptions, but all your money in the bank, your investments, your real estate that's not your home. If it's not your home or your car, it's likely to be a countable resource, and it's going to be an asset you're going to have to spend before you get any Medicaid assistance for nursing home care. So a deferred annuity is the type of annuity also called a tax-deferred annuity. It's where someone invests money and the funds are left in the annuity to grow, and the annuity owner at any time can cancel the annuity and withdraw the money, sometimes after paying a surrender charge. But nonetheless, they have the ability to withdraw the money from the annuity. And so those deferred annuities, those are countable resources. No protection there. Got to pull the money out of the annuity and spend it before any kind of Medicaid eligibility exists. Then there's the immediate annuity, and boy, I kind of struggled in my preparations for this one because I wanted to find all of the proper citations, and so I printed off a few of the relevant provisions of our Louisiana Medicaid eligibility manual. So as we start talking about immediate annuities, which pay out perhaps a monthly income to the annuity owner maybe for their lifetime or for a certain period of time. In the income provisions of our Medicaid eligibility manual, well, it's pretty clear. When they talk about annuities, it says right there, I don't know if you can see it, but it says under annuity, it says count as unearned income. So an annuity is income. The income from the annuity is income, because with Medicaid eligibility, you have to meet at least a couple of tests. You have to meet the asset test, and that's what we've been talking about so far. You can't have too many assets, but then you also can't have too much income. So we'll come back to the income stuff in a minute. But if you have income from an annuity, that is income that generally has to be spent on, even when someone qualifies for Medicaid because they don't have the assets, they still have to use their income towards their care, and then Medicaid would pick up the difference between their income and the cost of the care. Okay, so in those immediate annuities that provide income, that's income that would have to be spent on the nursing home, even if you pass the asset test. Okay, so I wanted to get through all of that to get to this little carved out exception. Sometimes it's called a kind of Medicaid compliant annuity. So here's the idea there, is that as I go back, this is the scenario where you have a married couple, one in the nursing home, institutionalized spouse, one at home, community spouse. And let's say they have $100,000 more than what that couple can have. You may remember I mentioned that married couple in 2019, one spouse in the nursing home, one spouse at home, can have $126,000. They only have to spend their assets down to $126,000 before the one in the nursing home would qualify for Medicaid. Again, the rationale, the one at home needs something to live off of. Okay, but let's just pick an example and say that couple has $226,000. They're $100,000 over the $126,000 limit, and dad's moving into the nursing home, right now, maybe yesterday, today, or tomorrow. And so they're thinking, no, we gotta spend that excess $100,000 down before we can apply for dad to be eligible for Medicaid. So under this carved out Medicaid compliant annuity kind of loophole, exception, whatever you want to call it, what the strategy is, and I've never personally advised anybody to do this, but I know it's been done, and quite frankly, I've been scouring all of the asset provisions of our Medicaid eligibility manual, including 5 or 6 pages on annuities. And there's rules that exist on annuities that were created before February of 2008 and annuities created after 2008. It's confusing, but here's my best interpretation of it. So going back to our example, couple has $226,000, which is $100,000 too much. Dad's going into the nursing home. They feel like they're stuck. So under this exception, they could take that excess $100,000 over the 126 and purchase an immediate annuity that's payable to mom. She's the community spouse, and convert that asset to income for mom. So how does that help? Well, it helps because to pass the asset test, at least in Louisiana, and again, the federal government makes the Medicaid laws and allows the states to enforce them. So there's some wiggle room among the states to do, to vary among these things. But really, I'm referring to Louisiana here. Medicaid looks at the assets of both spouses to determine whether they have $126,000 of countable resources. But when they look at the income of the spouses, they only look at the income of the spouse that's applying for Medicaid. They don't look at the income of the community spouse who's staying at home. That spouse's income is not counted. So the idea is convert this asset, this $100,000 asset that causes them to have too many assets, and convert that from an asset to income for the community spouse, which isn't counted for purposes of the institutionalized spouses Medicaid application. And so I think they kind of caught on to that, so they put some really heavy restrictions on people who attempt to do that. They say that that annuity, it must be immediate, it must be irrevocable, it must be non-assignable, the payments cannot exceed the life expectancy of the person receiving the payments. And then the kicker is that the state must be named as the beneficiary of that annuity for the total amount of the Medicaid assistance paid on behalf of the institutionalized spouse. So if there's some income being payable to the community spouse and the community spouse dies, to the extent there's future payments to be made, those have to go to the state to reimburse the state for payments they made on behalf of the dad or the institutionalized spouse. And if the state isn't named as the beneficiary, then the purchase of that annuity is considered a transfer for less than fair market value, and the full purchase value of the annuity will be considered the amount transferred. And that triggers all of these 5 years or more, ineligibility periods for Medicaid for that spouse who's in the nursing home. Okay, so let me try to sum it up real quick for you. The idea here, and before I sum it up, just do me a favor real quick, so that YouTube will put these videos in front of you. Click the subscribe button and then the notification bell. And if it provided you with some value, give it a thumbs up, and feel free to type in the comments below either your questions, your comments, or suggestions for future videos. Love to see that. Okay, in fact, this video was made based on a suggestion that someone out there made. All right, so the quick summary is, our annuities protected? The deferred annuity is a countable resource, got to spend it. The immediate annuity that just provides income, it's income that's got to be spent on the nursing home. There is this exception for the Medicaid compliant annuity where sometimes you'll see a couple convert excess resources to income for the community spouse, but there's a lot of restrictions on how that annuity must be set up, including the state designated as the beneficiary. And if you do it wrong, it's treated as a transfer of resources, which is going to make both spouses ineligible for Medicaid for 5 years or perhaps more. So all that in mind, what do? Well, you got to plan ahead, because primarily of this 5-year penalty period when individuals or couples transfer assets out of their name, either to children or to trusts for children or others. You got to plan ahead. You got to do this while you're well. If you're 65, 70 and in pretty good health, that's the perfect time to gather the right information to make sure you set things up the right way so things are protected. If qualifying for Medicaid is a concern, the multi-millionaire wealthy people, this is not a concern for them. They can afford whatever care they need. But the middle class, many of those get wiped out from a long-term care nursing home stay. So there you have it on are annuities protected in general? No, but there is this exception. Got to be real careful, and it's got to just the perfect situation. Sometimes it can help. It might help depending upon how long people live and how long people are in a nursing home and when parents pass away, because of this requirement that the state be designated as the beneficiary. So there you have it. Hope that helps. I'm Paul Rabelais. Bring your comments below. Again, subscribe, thumbs up, all that good stuff. We'll see you next time.